Donald Trump was removed in Maine by a lefty Secretary of State who's got a long history of palling around with Democrats. We're going to learn more about this woman, the woman who made this decision on her own, wasn't a judge, wasn't a lawyer, just decided, I'm going to look around the country on YouTube and see what I don't like about Trump, and then issued this ruling, which she just said now disenfranchises 300,000 people in Maine. And what's clever about this is it's cowardly. She will virtue signal with this entire opinion and then put a little bit of a stay in there pending further action in the matter, because Trump, of course, is going to appeal this over to the Superior Court there in Maine. And so technically she's removing him, but technically he's kind of still on the ballot. Now, the danger here is that what happens if something affirms the removal? Okay, in other words, Donald Trump might be on the ballot, but when you vote for his name, they may say that that ballot, that signature, right, his name in that location was not legitimate. So you might have a couple 100,000 people who vote for him, but they say, well, Superior Court says, no, he shouldn't have been on there. And so they relate the decision back to the original date that this was entered. So I can see that happening. I'm not sure that it will. I think hopefully the Supreme Court comes and clears this up for the whole country and gives these people their due course. But this is what this woman sounds like, and this is what her background is. This was a post over from Kanakawa the Great. You know who he is on X. I'm sure you're following him. If not, you should be. He is saying that Democrat Shenna Bellows unilaterally kicked Trump off the ballot. She did it on her own. There was no trial. There was nothing here. And we have a prior segment on this woman about why she should have recused herself. Trump's lawyers were saying she should have booted herself off from this decision making a long time ago because she is so biased. But these are some of the people that she was hanging out with. And you can see she posted this, looks like on Facebook, says from Shenna Bellows, birthday jaunt to DC for a Women's History Month event at the White House. And we're walking around today. There's her with Joe. So wonderful to see one of my earliest mentors, Teresa Younger, and the fellow first female secretary, Elaine Marshall of North Carolina at the White House reception. Amazing to meet President Biden. Grateful for the birthday wishes today. Ah, gosh. Happy birthday. Palling around with a bunch of weirdos. All right, here's another one. Happy birthday, President Obama. Here's to hope and change. Yeah. Do we have any hope and change from him? Are you kidding me? Gosh, golly. All right, so what a racket that was, wasn't it? Then here's this one. Shenna Bellows posts this. This split screen makes me so happy. I've long admired Stacey Abrams. I've long admired her, and to get to speak to a congressional committee today about the nonpartisan leadership Maine has demonstrated on voting rights night was so meaningful. Oh gosh, Stacey Abrams, one of the biggest, victim exaggerators in the whole country, right? And she was the one, also, she's an insurrectionist, by the way, as you know, because she said that she was the rightful winner of like every single election she ever touched. She's still upset about her student council election, back in high school. I was like high school. Relax, Stacey, okay? Just move on. All right, this is another one from Shenna Bellows, okay? Here this one is. I was so moved by this speech tonight. Thank you, Michelle Obama. Oh, gosh. All right, so this woman is obviously a partisan hack, and if you have any questions about it, this is what she was saying previously. And here is a report that was gathered by the Midwesterner, and he dug this up. He said, back in 2021, Maine Secretary of State Shenna Bellows appeared with Michigan Secretary of State. You remember her, Jocelyn Benson. And we were talking a lot about her back in 2020, and she's still around, right? We'll see what she does. But the Supreme Court in Michigan has said that they cannot remove them from the ballot. It's just a vehicle of law problem. But so Trump's currently on the ballot now, but we'll see what happens in the general. Yeah, it's a technical mechanism that makes him on the ballot. So she's there also with Colorado Secretaries of State also. Isn't this incredible? It's like three of the biggest anti-democratic people you've ever heard of. Maine, Michigan. Jocelyn Benson was changing all the rules in Michigan back in 2020. We covered all the election there with the Michigan Association of Retired People, right? Third parties who were funded by who knows who, all suing under COVID to change the rules. So Jocelyn Benson from Michigan, Jenna Griswold, who is in Colorado, who we just listened to earlier this week screaming about Trump, along with Shenna Bellows. It's like, the Trump removal Avengers or something. A far left conference here at Netroots Nation. And lo and behold, there's action in all of their states. It's like a conspiracy or something. Here's some insight in her philosophy. Okay, this is what these weirdos were talking about on this Zoom meeting. Oh gosh, could you imagine being on this meeting? Here's Michigan Secretary of State Jocelyn Benson. She's in her car with her AirPads. She got Jenna Griswold. She's in Colorado. Secretary Denise Merrill. Don't know where she's from. Carolyn Fiddler from the Daily Kos. Oh my gosh. And this one is Secretary of State Shenna Bellows. Let's listen. All right, hold on.
Secretary Bellows, would love to hear about your thoughts on the biggest threats facing our democracy at this point in time.
What are the threats facing our democracy?
Well, Well, what Secretary Griswold just said and named is something that was unimaginable 2 years ago or 10 years ago, and that is election sabotage. It is a crystal clear example of what's happening all across the country. So we need to organize to make sure we have better leaders in positions of power to fight back against that. Secretary Benson talked about voter suppression, and that's something that when we started our careers at the ACLU and Southern Poverty Law Center.
ACLU and Southern Poverty Law Center, okay? She's not a partisan hack.
Fighting back about systematic, structural voter oppression, targeting specifically Black and brown voters. It's rooted in white supremacy. That is something we have to continue to do work on. And Secretary Merrill talked about the fourth.
What is that? Can you please explain what it is? What does that mean?
The PEOPLE Act and the Freedom to Vote Act. We must have federal standards all across the country. And then finally, just to echo my colleagues, this is rooted in a deliberate and organized campaign to discourage people from participating in our democracy.
What? She just threw Trump off the ballot. Discouraging them from participating? Do you mean like disenfranchising 300,000 people? Do you hear these people?
It is an attack on our very democracy itself. Because when...
Okay, so by her own admission, she's an insurrectionist, isn't it? If you remove the ability for people to participate in the democracy, it is an attack on our democracy. And she literally just did it.
Everyone participates. Everything that we care about, social justice, climate justice, economic justice, we win. Those on the other side are trying to discourage people from participating. That's what this really is about. We have to fight back to protect our democracy, to protect everything.
That's such a good point.
Such a good point. Oh, gosh. Holy moly. Okay, I don't know, this is going to be a long show, isn't it? So that's who we're dealing with. Now, she didn't say much of anything, okay? It was a bunch of like talking points, all platitudes, one after another. Climate change, social justice, white supremacy. What is the white supremacist movement to disenfranchise Black and brown voters? What is that? Like, articulate that, please, for us. What does that mean? I don't want that to be happening. So can you tell us what that means? Or does that mean that you waive signature requirements? Does that mean that you just create ballot box drop-offs or something, right? That's what they're talking about. They use these other superfluous words to then really shoehorn in what they want to get done, which is structural changes in the election that give them power. It's not about disenfranchising Black and brown voters. What are you, nuts? It's about ensuring that they can print and stuff ballots wherever the hell they want them. And the FBI, when they investigate in Michigan, where there was all sorts of shenanigans there, we read the report that they tried to bury. FBI just investigates it and does nothing with it. But you see, it's like a little cabal. They should be charged with RICO for this little conspiracy to try to disenfranchise hundreds of thousands, millions of American voters. They dumped 1.3 million off in Colorado, Shenna, and they dumped another 300,000 off in Maine. And the list goes on and on. So there should be a RICO case if some Republican had the stones to do it. But they don't. And so we're going to now read the opinion from Shenna right after a quick message from our friends at VNSH. Just when I thought my gear couldn't get any better, I discovered VNSH holsters. This isn't just any holster. It's the most comfortable one I've ever strapped on. The VNSH holster fits 99% of modern handguns and holds 2 extra mag pouches, and whether you're right-handed or left-handed, it's got you covered. It's made from a durable Cordura and polyester blend, meaning it's very lightweight at just 6 ounces, but don't let that fool you. It's tough, adjustable. It's got a no-stink material, meaning you'll stay fresh all day. It fits up to a size 68-inch waist, and the best part is it's so discreet no one will know you're carrying a VNSH. And now you can be a part of the biggest giveaway we've ever had on this channel. One of you, my friends, can win this incredible Jeep Gladiator. And $25,000 worth of gold thanks to VNSH. To enter, all you have to do is click the link in the description and get yourself the most comfortable holster you've ever worn with a money-back guarantee. And VNSH is not done there. Get $40 off now when you use my link below, plus 120,000 bonus entries with each purchase up until December 31st. So get your VNSH holster today by following the link below and stay strapped, my friends. And now let's take a look at the opinion from Shenna, the person who is not a lawyer, who is not elected, who is the person who unilaterally decides Trump has got to go. This is from the Secretary of State, the ruling of the Secretary of State. Okay. Now, I do have questions about who wrote this. Do you think she sat down, the woman you just listened to, sat down and wrote 34 pages of this? Do you think so? I don't think so. Okay. Her vocabulary is not big enough. All she knows is social justice garbage. So let's go into this. She says, all right, these people called Kimberly Rosen and others are challenging this, trying to remove Trump from the ballot. There was no trial. There was no presentation of evidence in the ordinary sense. No jurors found. This is just her. She says, okay, on December 15th, I held a hearing, whatever that is, on 3 challenges. There were several challenges and they contest Trump's nomination under the 14th Amendment. Now, the 3rd challenge was filed by this other dude. He says Trump is ineligible under the 22nd Amendment. And this woman says, for the reasons set forth below, I conclude that Trump's primary petition is invalid. Specifically, I find that the declaration on his candidate consent form is false because he's not qualified to hold office under Section 3 of the 14th Amendment. So totally in agreement with the Supreme Court of Colorado and using that, as we saw, as evidence. Now, here's the procedural history, and I'm a little curious about this. They say the deadline for filing the petition was December 8th. In the first challenge, person Marianne is a registered voter of Winterport, said Trump violated his Oval Office. Same thing here. This guy, attorney Paul Gordon, registered voter of Portland. He says Trump is barred under the 22nd Amendment because of a 2-term limit. So that's a funny one, right? And we haven't seen this seriously be alleged, but this is, they said, well, Trump says he won. And so apparently he's still the president. And so he can't run for a 3rd term. That's funny. In a 3rd challenge, this other registered voter said, of course, again, the 14th Amendment. Now let's learn about this hearing. She said on December 11th, I issued a notice of a hearing to all parties. Right? She probably has this little room, where they're all sitting around with their coffees. And a consolidated hearing would be held on 10 a.m. 10 a.m. on December 15th. Not even 8 o'clock. You can't even get started early. How long is this meeting? The notice informed the parties that the hearing would be conducted under the law, and the parties exchanged exhibits and witnesses the afternoon of December 13th. Then we received the applications and here. Now, at the start of the hearing, I denied the intervention petitions of some of these other people because they weren't here, but without objection, I ultimately accepted their submissions as briefs. Now, at the start of the hearing, I noted that the following were already a part of the record. Okay, a bunch of stuff. Trump's petition, candidate form, challenges, blah, blah, blah. Without objection, I admitted some of these challenges. Now, at the hearing, 2 people, Miss Royal and Attorney Gordon, they testified under oath. The Rosen challengers called 1 witness. Okay, so just like when they say there was a trial, there was a hearing, there was due process. This is what they're talking about. Okay, 10 a.m., sometime a couple weeks ago, she calls in these 2 people, Royal and Gordon, and they call 1 witness, this guy, Professor Maglioka. He goes to University of India Law. Donald Trump called no witnesses. I heard argument on the scope of my authority, and without objections, I set a deadline of 5 p.m. for any other provisions. Trump filed some articulating objections and timely responded. No other party filed objections. And it's like, oh, look, Trump didn't file anything. And this is a sham. Okay, why would he engage with this total sham fake process to throw him off the ballot? Now, I likewise permitted the parties to submit final briefs. And here you go. Following the Colorado's decision, I invited additional briefing. And we read through that full filing here. There's a full video on it where they're objecting. Actually, the people are saying after Colorado, their updated position was that this secretary is allowed to just take the Colorado case. Okay, she can just take the Colorado Supreme Court decision using issue preclusion, which is something she has no idea what it even means. And it is that she can just take it in and accept it as though it's true without having to do a trial again. Now, Trump filed briefs before the deadline on Wednesday, 16 days after he learned that I would preside over the hearing. Then Trump filed a motion to disqualify myself because you're a biased partisan hack. Well, that motion, listen to her, that motion is denied as untimely. Okay, so she's just not even going to consider it. I'm not a partisan hack. You filed it late. See the rules. Timely charge of bias. You were too late. Had the motion been timely, I would have determined that I could preside over the matter. Okay, she doesn't care either way. Impartially and without bias. Okay, so yeah, I'm sure we've got all of your other prior statements and all your other garbage. Now, my decision is based exclusively on the record before me. No way, she says, it's no way been influenced by my political affiliation or my personal views about the events of January 6th. Okay, so she throws out her recusal request. Sorry, you're out of time, but I'm not biased anyways. Okay. Now, legal requirements here says a candidate needs to file a primary petition. We've got that, and that's all submitted. And here's what Shenna says to all of us. I have reviewed the exhibits submitted in this case, and I have carefully considered the arguments proffered by the parties. She says, I take my role in this proceeding extremely seriously, given both the stakes and the novel questions at issue here. And for the reasons that follow, I conclude that Trump's primary petition is invalid. Thanks, Shenna. Now, she says most of the evidence submitted is admissible. So she's going to go through some admissibility here and pretend like she knows what she's talking about. She says, Mr. Trump makes a blanket objection on due process grounds, which of course is valid because there is is no due process here, to the fact that he was unable to review the challenges. Now, as discussed, I already gave him a Dropbox link, and with assistance from my office, copies of evidence were also given to them during the hearing. This is such a joke. She's like trying to cope with the fact that there was no due process. And what are you talking about? We gave you copies at the hearing when you showed up and we sent you a Dropbox link. So this delay in reviewing any of the evidence, it's not a due process violation. There's no requirement that evidence be shared prior to an administrative hearing. You see that? There's no evidence. Like, you don't even get discovery in this little sham hearing that she's conducting. Now, when you have a partisan hack like this, it's even less, even anything resembling what you would expect in America. But the APA, that she says it mandates that all they do is show up, present evidence and arguments, and call and examine witnesses and make oral cross-examination there. And so Trump had those opportunities, and all the exhibits were submitted, and Trump was fully aware that they'd be offered against him at this hearing. And so there was ample notice, in part because the majority of the evidence was already presented, okay? So she didn't even accept new evidence. She said, you guys already saw this in the Colorado case, and you have the same lawyer here. So it's the same lawyers in two different states. Well, that's nice, but they're separate states and separate complaints with separate evidence. Are you saying that if you got charged and convicted with a crime in Colorado, you could just say, well, you did it over there, so I guess we'll just give you a DUI over here too? That's insane, but they're doing it. Now, I also afforded the parties 3 additional days after the hearing to organize their exhibits, and so his objection about due process is therefore overruled. Now, the notice provides, in stark contrast, they say Trump has handled 25 exhibits, never before referenced in this proceeding, that he cites in footnotes and other objections. And Trump has not requested that I enter these into exhibits, and nor would it be fair to do so over an objection 3 days after the hearing. So I'm not going to accept Trump's exhibits. Trump submitted an exhibit list prior to the hearing containing only 1 exhibit. He could have supplemented it, but he chose not to do so. And so therefore I sustain their objections, and Trump's evidence is not going to be admitted anyways. Say Mr. Trump also makes a blanket challenge to the relevance of their evidence. She says I overruled that one too. The meat of Trump's objection is that they're using the January 6th Select Committee hearsay report as evidence, and it's not. It is a sham document that has no cross-examination, no adversarial parties there, and is all hearsay. And by the way, the evidence has not even been preserved for completeness of evidence. So Mr. Trump's objections to the admissibility of their report are overruled. And she's free to do that because it's a sham hearing. She can do whatever she wants. Now, as an initial matter, Trump's objections hinge on the rule of evidence. And guess what? As we know, it's a sham hearing. The rules of evidence do not govern this proceeding. Now, that might be true, and they do that for all sorts of reasons. It's for expeditious processing of cases, right? Like at the MVD, you don't want the MVD to have to go a gazillion DUI cases with full evidentiary purposes and all that stuff, because it's a licensing thing. It's a minor thing, really. Like, you don't have a right to drive, to have a driver's license. You have a privilege. You're licensed to get that. And here, they're just going to say that you don't need this due process. But she admits here that the rules of evidence are not here. The rules of evidence we have written the way that we have them to abide by due process, to make sure we have good evidence, to make sure we have equal protection. And they are to create a valid and legitimate outcome. Now, she says they don't govern it. I'm sure it's true, but that just emphasizes what a joke it is. The fact this report includes hearsay, which she admits, the fact that it contains irrelevant facts or lacks foundation, which means it's terrible as evidence. Hearsay rules, relevancy rules, and foundation rules are not just neat things that we just do because we're bored. They make sure that the evidence is legitimate, okay, and credible, because you can cross-examine it. But she says it doesn't automatically render it inadmissible, so she's using the AP, right, her administrative rules to just throw it out. Rather, the central question is the type of evidence which reasonable persons are accustomed to rely on in serious affairs. And so she says, well, I rule. These people, right, these little tyrants with administrative power, says that the January 6th report meets this standard. Under the federal rules of evidence, reports of Congress are presumed admissible, she says, even though she's not adhering to the federal rules of evidence. Trustworthiness is assessed by 4 factors: the timeliness, whether the hearing was held, how it was conducted, possible motivations, and so on. And so all of these are admissible. But I am not bound by either federal or Maine rules because this is just an APA proceeding. But if I were to consider the 4 factors outlined above, I think it's admissible. Trump's objections focus focus primarily on the fourth factor, namely the motivation of the authors, but all congressional reports are to some degree political. Of course, yeah. And so she's going to use that to throw off her political opponent. Got it. And many of the facts contained in the report are corroborated by other evidence. And so I see no reason to exclude the J6 report. Trump's concerns are valid, though, insofar as it reflects a curated view of the evidence. And she says these limitations influence the weight that I assign to the report. It's either he's an insurrectionist or not, right? And she picked the decision. Now, Mr. Trump also objects to the records provided from the Colorado case, saying we can't just take Colorado's case. There was a trial there. There's no trial here. But she says here, Rosen challengers are not asking for judicial notice. They have sought to admit every exhibit individually. And the fact that the exhibits are associated with Anderson is beside the point, she says. This is sufficient, and so Trump's objection is overruled. Trump also says that there are other objections, and I sustain some of these. She says, specifically, while I'm not obligated to exclude irrelevant evidence, I do exclude some of these evidence, like speeches, town halls, and conferences. She dumps things from 2015 to 2019 and 2023. She says they're too remote in time. Okay, so it goes too far back before J6 and too far after. And so, okay, I'll leave some of that evidence out. But otherwise, all Trump's objections are overruled. If he has concerns about authenticity or foundation or completeness or hearsay or improper legal argument, they don't render these exhibits inadmissible, and I find them reliable. Now, in sum, I sustain Trump's objections to those other evidence because they're not needed here. But she says, with all that said, I have the authority to keep unqualified candidates off the ballot. She says, as a general matter, consistent with state authority to regulate time, places, and manners of the election, I'm allowed to do this. The inevitable result of states managing their own elections with respect to presidential candidates means sometimes people will not appear on ballots. For example, Biden's not going to appear in New Hampshire. Did some secretary throw him off? Is that what happened? Or was that his campaign's decision? At the same time, Mr. Chris Christie is not going to appear in Maine's 2024 ballot, even though he's going to appear on New Hampshire's. But that's because he's unqualified. Okay, he didn't get enough signatures. All right, nobody threw him off. He was just not qualified under the rules. So she's going to make that same analysis, right? So this happens all the time where perfectly qualified candidates are thrown off. No, Joe Biden made that decision and Chris Christie failed to secure enough signatures or whatever that issue was. Similarly, while state legislatures cannot create new qualifications, they can choose to establish a process if people fail to meet the standards. Now, that is the authority, and we've explained this here before about how legislatures are so pathetic that they delegate all of their power to someone else, some other bureaucrat who's willing to take it because they're petrified about, losing elections and doing hard work. So they just delegate everything over to the executive branch, which is pathetic. Now, as the Rosen challengers note, the Secretary of State is statutorily obligated to determine if a petition meets the requirements. And there's a lot of things that I have to consider. And Maine tells me that I have to review the accuracy of a candidate's declaration. And so I therefore disagree with Mr. Trump's contention that only Congress can adjudicate the qualifications of a candidate. The state has the power to, and they have granted me the authority. It says first, the authority is not limited to specific qualifications set forth on the consent form. And for this reason, the declaration on the 2024, which asks candidate to confirm that they meet the qualifications, Trump says that he's there. But they argue about this word as. They say Trump is saying that he should meet the qualifications to hold this office as listed above. And she says the word as is important. If the word as was not in there, it would limit the scope of Trump's claims. But its presence underscores that the qualifications are listed on the consent form as a convenience. The qualifications as listed above, consistent with the rules. Any other interpretation means I'd be reading this wrong. And second, the form separately refers to a candidate's place of residence. Counsel for Trump, who is his co-counsel, admitted at the hearing that the declaration was legally indistinguishable. And so here I have authority, according to the forms, to keep clearly unqualified candidates off the ballot, right? I have the power to do this. Saying that Trump's false claims about the election do not disqualify him under the 22nd Amendment. Okay, so Trump has said, I've been president, right? I was elected. And so Gordon, this attorney, has said that Trump has said he's actually been elected twice. But when questioned at the hearing, Gordon said as a factual matter, Trump did not win. And so he's actually not the president, so she skips over that. But now we get to the juicy bits. Subsection D. This insane Maine secretary says, Mr. Trump engaged in an insurrection, and that means he is not qualified to hold office. Saying the exercise of state authority to keep unqualified people off the ballot means we have to follow the process. And there's no other mechanism by which I'm aware of that Maine voters can challenge this. And so I am authorized, and I'm duty bound, she says, to follow the Constitution. Now, the question of whether this is applicable is pretty straightforward. If there's a dispute about validity of the signatures or the candidate is underage or incorrect jurisdiction, then we may not need to take a lot of evidence because we just know, hey, you're 16, you can't run for office. But rather, I'm tasked with determining this case. Now, the secretary has wrestled with complex evidentiary issues before. She says, I'm competent. I can do this stuff. Other secretaries have done it before. We reviewed this one, which was complicated, and we reviewed this one, which was complicated. And so I can review this one. And yes, it is a little complicated, but complexity is not a limitation on my authority. And so I have the power, even though I'm not qualified and biased, to review this. Now, these statutes do not suggest I'm restricting adjudicating this, nor do I have the discretion to decline to rule on this. So I have to make a decision, and the statutes mean that I have the authority to me. The legislature has once again given me the power to do it. Saying Mr. Trump's concerns about the adequacy of this proceeding are therefore without merit. I'm qualified. I'm great. I'm, who she is. He says Trump has had the opportunity to present evidence. He's been able to call witnesses. He's been able to cross-examine them and to argue at length about all the issues that are germane to my decision. And while the timeline of the proceedings has been a little bit compressed, she admits, this is hardly the first time that they've confronted the 14th Amendment, okay? So they already are familiar with this. They already did this in Colorado. They're gonna have to do it again, I'm sure. And it's likewise not the first time that Trump has had to grapple with whether evidence is presented here, it directly mirrors his insurrection. And he has the opportunity to appeal my decision at the Superior Court and others. Now, while I'm cognizant about the fact that my decision could soon be rendered a nullity by SCOTUS, the possibility does not relieve me of my responsibility. And so I therefore conclude that I am a little dictator. I've got the authority to disenfranchise half the state. Saying Section 3 is, in fact, self-executing. We don't need Congress. We don't need an impeachment and a conviction. We just need some secretaries and some Supreme Court to just figure it out. Saying here, Section 3 refers to holding office rather than running for office. Now, Article 2's qualifications do not refer to running for office. And so my obligation is to keep unqualified candidates from taking office. Saying I'm going to do that here. Why? Because no congressional action is necessary for Section 3. She's going to give us some legal analysis, I guess. The Supreme Court described the 14th Amendment as undoubtedly self-executing. We've already seen that quote as applied to the 15th Amendment. Contemporary evidence says the same is true of Section 3. Both the military and the states themselves and blah, blah, blah. We've seen this. Now, I recognize that Section 5 of the 14th Amendment says that Congress shall have the power to enforce this. But that does not mean that the 14th doesn't have any legal force. It stands to reason, like Section 1 of the 14th, the Supreme Court has said that's self-executing. And so I'm just going to presume that this is also self-executing. Saying the presidency is also covered by Section 3. Donald Trump is an officer. Saying the Constitution repeatedly refers to the presidency as an office. At first blush, it would seem odd to interpret this as it incorporates the president, but none of these enumerated positions are offices under the Constitution. Saying the history firmly supports the idea that Section 3 covers the presidency. So this law professor, Maglioka, he comes in and he says, members of Congress believe the presidency to constitute an office. I definitely think it's an office, definitely, as did other contemporaries. Now, Mr. Trump cites an early draft of Section 3 that referred to the office of the president or the vice president before they deleted that. But the Rosen challengers say that the early draft confirmed that they intended the presidency. So they wrote it and then they deleted it. They wrote the first one is what they really meant. The language adopted was much broader, they said. And this not judge says, this makes good sense. It's implausible of the drafters of Section 3 to choose to exempt the highest office in our government. It's not implausible. It is literally by design, okay? It gives the people the power to override the veto. If Congress by statute and legislature decides that nobody else can run because they've decided that, it eliminates that from the people. The people get to decide who holds that office, not the legislature. It's by design. And we've already talked about the geographic connections with the representatives and the other offices. Jay Sekulow, in a prior video in his office, put together a beautiful motion as an amicus brief to the Supreme Court. Now, the uniqueness of the president's oath does not change the calculus either. We have talked about that a lot. And the record also demonstrates that J6 was an insurrection. Saying the parties don't meaningfully dispute the events of J6. There was a lockdown. There was an evacuation. It was 7 hours. 2,000 protesters entered the building. 7 hours, like 4. I mean, they came back. They voted the same night. It was a joke. The attack resulted in assaults, they say, on 174 police officers that had a strong breeze push them in the shoulder. And here, in making their case, the Rosen people rely on the proceedings. They refer back to Colorado, the Anderson case. And Magliuca defined this. He went to the American Dictionary. He called an insurrection anything rising against a civil authority. Now, Trump says that his offer of a definition is weak. Insurrection must be long enough and significant enough on the way to a rebellion. But I don't like like that standard. In fact, an insurrection doesn't even need weapons, okay? Military weapons like guns and swords are not necessary for an insurrection, which is strange because I don't know how you take the country over if they've got guns and weapons and the other side doesn't. But here, the evidence shows that January 6th meets the standard. Lots of people were hurt that day. Crowd ultimately entered the Capitol after they were waved in, tapped on the shoulder, come on in. It also cannot be reasonably disputed that the rioters were organized behind a common purpose. What, to protest? The purpose is evident, not insurrect the country. They were going to walk out of there with the nuclear codes, but they were present to stop the steal, to protest a rigged election. And so she calls it a violent disruption of Congress, and that is enough. And the record demonstrates that Trump himself engaged in this. It would not be difficult if he had actually been found guilty or not guilty of insurrection. Well, he's not even been charged with this, Shenna. And he also was acquitted. He actually was found not guilty in the Senate. Did you forget about that one? The applicability does not turn on whether an office seeker has been convicted of a crime. And so I'm obligated to assess the record before me with or without any due process. And so on that basis, I adopt Professor Maglioca's decision, some front law professor, that Trump engaged in insurrection and he is incitement. He incited the insurrection. And before the 2020 election, Trump sowed doubt in its legitimacy because it was illegitimate. He declared, for example, at a campaign rally that the election is rigged. It was rigged. FBI rigged it. All the state courts rigged it in collusion with the secretaries of state, many of whom we listened to earlier in this segment. So Trump repeatedly claimed 51 ex-CIA officers in obvious collusion with current CIA officers and FBI agents were censoring and rigging everything everywhere we looked. So in response to Trump's inflammatory rhetoric, a Republican election official warned Trump, stop inspiring people to commit acts of violence. He's not doing that. Never was. This is a wild written opinion here. It says the language that Trump used was often inflammatory too. So all of this is speech. It's all free speech, but that's evidence of an insurrection according to Shenna. Trump posted some tweets and she doesn't like those, probably keeps her up at night. Trump learned the Capitol was under attack at this time and he sat around. This is a Liz Cheney argument we're familiar with. And you see, in conclusion, this lunatic says, I do not reach this conclusion lightly. Yeah, you do. And, I doubt she wrote more than 5 sentences of this, but says, I do not reach this conclusion lightly. Democracy is sacred. Democracy means the people have a participatory role. And at the highest court of this state has repeatedly recognized that no right is more precious in a free country than having a voice in the election, as she makes an opinion depriving people of the vote. I am mindful that no Secretary of State has ever deprived a presidential candidate of ballot access on Section 3 of the 14th Amendment. But this is her moment to make history. Okay, she's probably going to get a gig on MSNBC and a book deal. Now, I am also mindful, however, that no presidential candidate has ever before engaged in an insurrection. Now, the oath I swore to uphold the Constitution, which she is shattering in this very opinion, and my duty under Maine's election laws when presented is to ensure that qualified candidates appear on the ballot. Saying the events of J6 were unprecedented and tragic, caused by our failed security state. They were, or exacerbated or instigated, they were an attack not only upon the Capitol, but also an attack on the rule of law, which is what this entire opinion is. The evidence here demonstrates that they occurred at the behest of Trump, and the U.S. Constitution does not tolerate an assault on the foundations of our government. Where does the Constitution say that? What is she talking about? Now, I conclude that the Rosen and Royal challengers have met their burden. They have provided sufficient evidence to demonstrate the falsity of Trump's declaration, and so therefore, I find the primary petition of Trump is invalid. A Democrat partisan throwing a Republican opponent off the ballot. Now, this is the most pathetic part of this whole thing, all right? She signs this like an 8-year-old who just is working on her cursive, nice job, Shenna, and says, given the compressed time frame and the novel issues involved, the importance of this case, and the impending ballot preparation deadlines, after all of that bloviating virtue signaling garbage that she, somebody, regurgitated out of her office, says, I will suspend the effect of my decision pending appeal. Oh, great. So he's going to be on the ballot, Section 337, until the appeal has expired. Thanks for that. Noting administrative agencies are free to fashion their own rules of procedure. Now, Trump is obviously going to be appealing this to the Superior Court, and we're going to be awaiting SCOTUS to come in and clarify this stuff. But these people are fracturing the country in real time. We're watching it happen, okay? We have now a split in the states, Colorado, and we've got Maine, who are removing him. We've got Michigan, which is currently keeping him on the ballot, and more things are percolating out there. And so an insane ruling from an insane Secretary of State in Maine who's just said, I've got the power to conduct a fake sham administrative hearing. I don't know how long the hearing was. I was hoping that we would hear that, but it started at 10, so probably over that day, right? Like before lunch, probably. probably. And she issues her ruling, and now this is where we're at. It's sick, and these people think that this is all done in the name of democracy. Again, if Trump is an insurrectionist, okay, if all of her opinions are so clear and all of this evidence is so obvious, leave him on the ballot. He'll get blown out. He'll get 10% of the vote. But nobody believes that. And they know nobody believes that, which is why they have to remove the choice from us and then say this is all in the name of democracy. Even CNN is showing that this is a total joke. Our friend ALX on X clipped this, and here is what they're talking about there.
Were the processes, were these hearings fair? Did they comport with due process? And I think there's a question there with regard to what Maine did, because if you look at the hearing, and she details this in the ruling, they heard from one fact witness, a law professor. She based her ruling on a lot of documents, but also YouTube clips, news reports, things that would never pass the bar in normal court. She's not a lawyer, by the way. It's a smartly written decision, clearly consulted with lawyers, but this is an unelected. She's chosen by the state legislature.
She's elected by the
chosen elected by the legislature, but not democratically elected. Not a knock. That's just the way it's set up in Maine. And this hearing, look, it doesn't have to be a criminal trial. We don't have all the protections. But I think the argument you'll hear from opponents is, one, not up to the states to do this. This is why we have all different decisions from all different states. And two, the procedures were not up to snuff.
Total sham. He knows it's a sham. She knows it's a sham, but she's going to get a book deal out of it. So we'll see if she does. Now, Thomas Massie had an interesting take on this. And you remember that the House has the opportunity to reject some votes. And so Thomas Massie has a good idea. He says, Maine, Colorado, and other states that might try to bureaucratically deny ballot access to any Republican nominee should remember this. The U.S. House of Representatives is the sole and ultimate arbiter of whether to certify electors from those states. So maybe the Republicans, if they continue to control Congress at the next counting of the presidency, that's still, a year or so away. Maybe we have another person drop out, with some other scandal or whatever. But Thomas Massie has a good point on this. Maybe they just reject the votes. And yeah, that's Thomas. So I think an interesting idea. We'll see if that ultimately comes to fruition. But the Donald Trump campaign has responded to the Secretary of State's ruling. Trump says in response to being thrown off the ballot in Maine that the Maine Secretary of State is a former ACLU attorney, a virulent leftist, and a hyper-partisan Biden-supporting Democrat who has decided to interfere in the presidential election on behalf of crooked Joe Biden. We are witnessing in real time, this is absolutely true, the attempted theft of an election and the disenfranchisement of the American voter. Now, Democrats in blue states are recklessly and unconstitutionally suspending the civil rights of the American voters by attempting to summarily remove Trump's name from the ballot. Make no mistake, these partisan election interference efforts are a hostile assault on the American democracy. Biden and Democrats simply do not trust the American voter in free and fair elections. They're now relying on the force of government and their institutions to protect their grip on power. State courts in Michigan and Minnesota have rejected these bad faith, bogus 14th Amendment challenges, as have other courts in New Hampshire, Arizona, Florida, Rhode Island, West Virginia, and 10 other federal jurisdictions. We know both the Constitution and the American people are on our side in this fight. President Trump dominating campaign has a commanding lead in the polls, and that has dramatically expanded as Crooked Joe's presidency continues to fail. They say from Stephen Chung, Trump campaign spokesman, that we will quickly file a legal objection in state court to prevent this atrocious decision in Maine from taking effect, and President Trump will never stop fighting to make America great again. Boom. Nice statement there from Stephen Chung, Trump campaign spokesman, and absolutely right. It's a wild scene. We're going to wake up, we're going to look backwards in hindsight, and we're going to say, oh yeah, that's when it all started, right? That's when all of the fractures started. In the name of democracy, we're shattering democracy, shattering 234 years of precedent with criminal charges. She admits, Shenna, never has this ever been done before, just pulling them off the ballot because they're out of options, man. They have no choice and they're freaked, which is actually pretty good news for our side. So we're going to keep on this story, my friends, covering all the Trump cases here. Thanks for checking out robertgovea.com. Don't forget to sign up for the January Fitness 2024 challenge at our new location for community activities, the Watcher Lodge. Go to watcherlodge.com, click this community calendar tab, and register for the fitness challenge in 2024 so we can all start the new year off healthy and feeling a little bit in an improvement mindset as we're dealing with all this madness and nonsense. And so we'll look forward to seeing you there. We'll look forward to seeing you back here on the next one.